and call us if you have a question. To answer those questions tonight, Abha Singh, she's a lawyer and activist who joins us right now. Anand Patwardhan, ex-president of the Consumer Guidance Society of India, who's also on the show. And Shweta Pathak is an advocate who joins me from Delhi. I want to thank our panelists for taking time out to help us out. Viewers, pick up the phone and call us if you have a question. Abha, I'm so glad you joined us on the show again, because the last time you were here, we received a tremendous response on this very topic. And there were some things that came up during that show and that conversation that I want to remind our viewers about. And one of the first things that came up is the simple right for women to own property. A lot of times, and I've done a lot of work for over a decade in personal finance, and I know there are various women across the country who sort of take a step back and not insist that their names be put as co-owners on assets that their family owns, because they want to keep the peace in the family. That's a very dangerous thing to do. Tell us why it's important for us as women to sort of insist that we become co-owners, to insist that our names be put on registration papers of properties.
Primarily because then you become the rightful owners. If something happens to your husband and you as a wife have put everything in his name, then you stand to lose, because his property would be divided equally. If there are children, you will get only one share. In spite of paying for the property, you will get an equal share. That means if there are 3 children, then the property would be divided into 4. If he has parents, they will also have a claim. So that means it gets divided into 5 shares. So rightfully, something for which you have paid, you should have been a rightful owner. But because out of your love for the husband, for the love of the family, you stand to lose your ownership. Also, if you don't have a property in your name, it is very difficult to get any loan, because you are unable to give any collateral. So, in fact, world over, if you see, there are only 1% property across the world is owned by women. I think that is primarily because of their giving nature, of their nature to be in the background. But that is the reason so many times women are on the streets if either their husband dies or they have a divorce, because when the divorce takes place, your maintenance would be very paltry, because the property is in your husband's name and he would decide what share you are going to get. And to go to the court, these divorce cases take years. However, now family courts are insisting that you should wrap up the process if it is by mutual consent in a span of 2 or 3 years. And if there is a dissent,
yeah, I want to just drive home this point. I want to just drive home this point.
Divorce, you are there to lose everything. In the case of demise, you get only one part of the share. So it is utmost necessary that a woman always puts her name on the property which is being bought in the family.
Always put your name on it for women to find out more details about if they're part of an HUF, how that HUF functions, what rights, who owns what, and where all the money lies.
Definitely, as you say, as my earlier speaker was saying, in HUF, daughters are co-partners, but daughter-in-laws do not have a very clear say in that. But through their children, they generally get the fruits of the property. However, of late, the daughters-in-law, as you're saying, a lot of wives are raising the issue that they should get a part of the property in their father-in-law's property, because usually it happens that when a divorce is about to take place, the husband very intelligently transfers his property, whatever he has in his name, either to his parents or to his brother, and thereby on paper he shows that he has no property. And that is a very intelligent way of avoiding giving anything to your wife. So that is why this bill is pending in the in the Parliament. A lot of MPs are agitating. They don't want this to happen, because in a city like Mumbai, a father-in-law would always say that it is my hard-earned money, but there is a criminal aspect to it. If a husband, after a divorce case is filed, tries to transfer his property, then the woman who's going in for divorce can file a case against him of cheating, and that is the way you can get a share in the property. However, whatever is clear in the husband's name, the wife has a claim only to that as per the law as on today. So definitely daughter-in-laws do not have a very clear standing in divorce cases, but to their husband's property they have a right to it. They have a right to live. The courts are very clear that women must be given a place to stay in the same house. They can be given a separate area. So living rights they have, but what alimony they will get, it will be something which they are able to prove to the court that what is their husband's earning. And also now it is said that a woman would be given alimony to the amount, to the lifestyle which she has been used to.
All right, just wait, Shweta, we have an anonymous caller. Okay, Abha, go ahead. Go ahead, Abha.
One small thing I would like to tell here in divorce cases especially, it would be very intelligent on the part of the wife to have an idea what is the tax her husband is paying, because once you separate, it is very difficult to get your husband's income tax returns. So in case there are cases where women have documented these things, they have got a very good substantial alimony, because later on the husbands are not ready to share any of their personal papers, and women cannot prove that the amount of money the husband earns, what lifestyle the husband has. So it is necessary that even when you are in a very good relationship, it is in your interest that you must know what your husband's income is, what income tax returns he files, what is the property he is inherited, what all properties are in his name. So these things should be there. It is not necessary that even when you are in a healthy relationship, you should not talk about it, but an intelligent woman would be one who would know where she stands in the family, what are the assets are there in the family.
All right, so it's not about how much money you have, but how much information you have about your assets that will really put you in a good position to find out what the case, or in a similar case where there is a registered will that bequeaths everything to the sons and nothing to the daughters. Now, the case that our caller was talking about, it's not being contested. But if one of those daughters wanted to contest such a will, because it's within the daughter's right to inherit, can she do so?
See, there were two things. If it is an ancestral property, the daughter has full rights to contest, because ancestral property will devolve on the son and daughter equally. However, if that property has been bought by his own money, the father has earned that property, then if he has made a will registered, then it is final. Even if she wants to contest, she would stand nowhere, because that particular property was bought by the father in his lifetime. It was not inherited by him. So in inherited property, the daughter can contest and she would have an equal share as per the Succession Act and the new law which came. But if it is ancestral, she has full rights, equal rights with the son. But if it is property is earned by the father, then, and if there is a will, then it will be the will which is final. It cannot be contested. However, there is another catch in this, that the death of the father should have taken place after 2005.
All right. What happens before 2005, Abha Singh?
See, as per that, it said, you know, this law is applicable after 2005. So here women have absolute equal shares, but before that, ancestral property, it was women did not have a right to inherit the ancestral property equally.
All right, so here's my question. If as a woman I'm required for whatever reason right now to approach a lawyer to fight for my rights, whether they're rights in inheritance or their rights in separation or divorce, tell me what my first steps should be. How do I find a lawyer that I can trust? What should I keep in mind? What sort of document should I have in hand?
That is the first thing which you said, whom you can trust. So you require a lawyer who would stand by you, who would be there in the court at the time of hearing, does not let you down. I mean, so that is main thing is you can trust, who knows the law and who is sincere. So first thing is finding a good lawyer. Secondly, as you said, the Sridhan, when at the time of divorce in the family court, when we go, you have to give a list. Women don't know what gift they have got. So I would advise through your channel that whatever jewelry you get, please take a picture. At times it happens that you initially put all your jewelry or Sridhan in your mother-in-law's locker. So at that time, keep it in mind that you put your name in those boxes, so that later on, when through the court's order you go to with the police to open those lockers, you can categorically tell that this is my jewelry, this is hers, and you can rightfully take your Stridhan, your jewelry. So that these things, as I said, you must be always alert, and a little diligence will help you later. You may not require at any stage, your marriage may be successful, but nonetheless a little precaution is very necessary. Thirdly, when you give the notice, at that time only, at times what happens, there can be a dowry harassment case like domestic violence or 498A, that was the dowry harassment case. So when you file that, there's 3 years imprisonment, and there's a police case. So you have to see whether it is a divorce by mutual consent where both the parties are willing. It is an irretrievable breakdown of marriage. That would be one part of a thing, which would be could be decided in 6 months also. You would have initial 1 or 2 counseling sessions. But if it was by mutual consent, then it is easy. But if it is 498A, then it is a long drawn process. It would be, it can be your in-laws, anybody from husband's side who's harassed you for dowry, you have a right under 498A. However, it is a different course that now the Supreme Court has given clear instructions that 498A should not be misused, and the police, the magistrate should be extra careful and ensure that people are not unnecessarily arrested. So this can be 2 ways. One would be by consent, or one would be through the long drawn process. Once the notice is given, the other party would come. In the court, it will be in the family court. Like in Mumbai, you have the Bandra court. There the case would come up for hearing. There would be counseling sessions where the judge would give you time to see whether you can work out your marriage. But if it is convinced and the parties are not ready, and then a divorce would take place. But again, the maintenance, one is the maintenance which would come in the family court, but otherwise 125 of the CRPC talks of maintenance for the wife and the children, which would be till the time the divorce is finalized. So in fact, 125 CRPC, even the Muslim women benefit because their maintenance is just for 3 months. But now a lot of my women clients who are Muslim, who are going in for a divorce, we try get them maintenance under 125 of the CRPC.
All right, we have to take a quick break. Abha Singh, what advice would you give her? So she's got an NOC from one of the uncles. The other two, they don't have an NOC from. How does she deal with this now?
From what she's talking, I can make out that the property was never transferred in her father's name. Her father was staying there. The share certificates were in the father's name. I would like to tell her, just by having your name, this is for everyone, that just by having the flat in your name in the share certificate of the society, you do not become the natural owner. Even in such cases, it is the inheritance laws which prevail. So, number one, the property was not transferred in her father's name. It's the succession, the share certificate does not entitle her father to be the owner, since it was her grandfather's property, and the other uncle never gave an NOC. So they also have a right to that property. And since her father is no more, the flat father's share, if there are 3 brothers, it becomes 3 shares. If one is relinquished, then also there will be 2 shares. And in that 2 shares, 1 share which is her father's, that would be divided between her mother and her other brothers and sisters who are there. But if they want to give an NOC, they can give an NOC, and then only that much of her father's share would be transferred to her mother. However, the uncle who did not give an NOC will always claim, and he can go to court and get his share.
Right, so he can go to court and get his share. Shweta, divorce. Does the daughter of the first marriage, being the oldest daughter, I think the fact that she's a daughter at all, have right to this inherited property?
Of course, she may be the oldest or the youngest, but she would have her share in that. But the second wife, if it is a legitimate marriage, legally married, then the children from the second wife would also inherit. And these inheritance rights of the children are governed by the Hindu Succession Act 1956. So as per that, she would get her share, but the other children also from the marriage would also inherit a part of the share.
Also inherit. So the in here, whether it was because of adulterous activities or not, I'm going to set that aside because the reasons are immaterial. At divorce, does the wife maintain her right to what is effectively Stridhan? This is what we talked about. which she received as gifts from the husband's family and from his friends and from his close relatives?
See, the definition of Sridhan is very clear. Whatever gifts, jewelry, ornaments she gets at the time of marriage, it doesn't say that what has been given by her parents, but at the time of marriage, whoever. So that means if her in-laws have given her some jewelry, in-laws' relatives have given her some jewelry, all that would be a part of the Sridhan of the wife. And if the divorce takes place, she is the legitimate owner of all this jewelry, which would become a part of the Sridhan.
Right.
Nowhere in the law it is differentiated that something which is given by her parents or her in-laws.
All right, we have one more answer from Abha Singh here. The bank has automatically passed on the loan to the wife, but somehow the rights to the home get divided among all possible successors here being, the mother, the child, the wife, everybody all around. Is there some way that there can be some sort of justice brought into this, some sort of logic?
It would be justice for the parents also. What about that? The Hindu Succession Act 1956 very clearly says that a property estate, if a person dies without writing a will, it would be divided among the class 1 relatives, and in the class 1 relatives comes the wife, the son, the daughter, the parents, that is the father, mother, and then so on. So here in this case, the father and the mother would also say that we have lost a son and we also need a livelihood. We were dependent on the son. So these are the things which come in, but since she is paying the EMI, she can always claim a larger share to the property because she has to maintain the EMI, prove to the court that 1/3 or 3/4 of the property has been paid by her. So proportionately, she should get a larger share.
Proportionately, she should get a larger share. Right. Okay. Unfortunately.